Welcome to Loopholes and Lawsuits. I'm Jamie Schrabeck.
And I'm Mike Vo.
Hello, Mike, and Happy New Year.
Happy New Year's to you, Jamie. It's been too long since we've last discussed about life and professionally.
It has been a while, and I know that the new year is a time to rethink our businesses, our careers, and I hope that we get the chance to do that today with a focus on liability.
Yes, there's a lot of issues with liability. Here where I am in Southern California, there's been those wildfires, and I haven't talked to anyone personally who has a salon in the affected wildfire areas, but I suspect there are a couple of salon owners who probably tragically suffered the loss of their salon in those fires.
We can take a broad approach to that term when we discuss liability in our businesses because we have it whether we realize it or not.
Liability could be either a customer liability, an employee liability, a landlord tenant type of situation where there's a liability, an act of God. Those wildfires have been going on. So there's all different kinds of liabilities, some of which you can insure against, and others, if something were to happen, you're kind of paying out of pocket.
Mike, would you read us our disclaimer first before we get started?
Sure. So the information and advice provided today is not intended to be taken as and should not be construed as legal advice. No attorney client relationship is formed through any of the discussions on today's podcast. You must consult your own private attorney for issues that are specific to your situation. Further, all topics of discussion are based on the law in effect at the time of taping. Please make sure to check for later podcasts of loopholes and lawsuits for any changes in the law.
Thanks for that, Mike. I know that we do that every time, and those of you who watch us regularly may know it by heart by now.
Well, that's a liability. It's another area of liability, right? So what we do, or in particular, especially what I do as an attorney, I have to make sure I'm protected against liabilities in any way related to our podcast here. So running a business has a whole set of challenges. Let me ask you, Jamie, as an active licensed manicurist and having your own salon, what are the liability issues that you've faced or have heard of, let's say, in the last 3 years?
Oh, I look at this at so many different levels. I think just as a licensee, your first issue is that you're working with people. And in doing your work, we are restricted by our scope of practice. So, working on consumers, we have to avoid hurting them. And one of the first things that we have to do is make sure that we're working within our scope of practice so that should we injure someone and we were to be held liable for that injury, that we can defend ourselves as licensees. The idea that professional liability insurance is something that's a best practice but not required may come as news to those of us in the industry who hadn't thought twice about doing their work, whether it was hair, skin, or nails.
Right. I definitely do recommend that all licensees, especially owners, carry professional liability insurance. I, as an attorney, carry my own liability insurance. It's when you least expect it, right? That somebody got hurt or you made a mistake in delivering your professional services when that lawsuit comes. I know they get expensive. When I defend these type of cases, it could easily run up to $150,000. In more extreme cases, let's say the customer has to have some type of medical treatment because of some type of personal injury related to those services. You're not only liable for the harm to the customer, their medical expenses, potentially you could be liable for their time off from work, their wages. So there's a lot of issues that come up when a customer is hurt by the way we perform our services.
My understanding is that even if you weren't the one responsible, you'd still have to defend yourself if a client claimed that you were.
Right. So the way it works in California is any customer in this specific scenario can sue the salon and the manicurist for their injury. And even if you, as the manicurist, believe you did nothing wrong, the salon says, look, we did nothing wrong. There's still an obligation to defend the lawsuit. And that first act starts off with appearing in the lawsuit. And then if you're going to litigate it, then there's a process of discovery where information is exchanged. And hopefully, ultimately, it results in some type of resolution by way of a settlement, not a trial. But what happens is the salon owner and the managers have spent X amount of dollars in their defense. So what you're hoping that occurs is if there's professional liability insurance and the allegations are such that it falls within coverage afforded under your professional liability insurance, rather than paying out of pocket for your attorney's fees and your defense, that will be covered by assigned insurance counsel. And also any settlement, any payment, or even a judgment, if it were to go that far, would also be covered by the insurance carrier.
That makes professional liability insurance the best investment you could make.
And that's why I always recommend if you can afford the insurance, you need to buy it. There's other insurance. So we talked about the customers, right? Employees. So if you are now an owner, one of the exposures you have is claims for wage and hour, meal break, rest break, overtime. You may potentially have claims for discrimination and or harassment, right? So there's a certain type of insurance policy called an EPL, employment practices liability policy. I do recommend my clients to carry EPL if they can afford it. It's not a cheap policy, but employment defense is very, very expensive. Now, I want to share that one of the caveats with an EPL policy is that it does not cover defense or payment for wage and hour based claims. So, for example, if you only had a claim against you for non-payment of wages, violations of overtime, meal break, and rest break, that's all it is. There's a high chance that the insurance company would not accept what we call your tender of defense and indemnification. They're going to say that the policy doesn't cover wage and hour claims. And if you kind of think about it from a public policy perspective, we don't want a situation where, let's say, I open up a manufacturing or salon and I hire a bunch of manicurists and employees and I work them to death. I just work them to death and I don't give them their breaks, proper pay. And then they sue to enforce their rights. And I say, hey, I have an insurance policy. We don't want to condone that kind of behavior. We don't want to encourage that type of behavior. So most EPL policies will not cover wage and hour claims. They will cover harassment and discrimination. The thought being is that most of the time in those type of situations, any alleged act of harassment or discrimination was not intentional. There's definitely disputed facts as to what was said or what was heard, maybe what someone did. But for the most part, when I see cases of harassment, discrimination, it's not intentional. For the ones where it is intentional conduct and there's evidence of it, what insurance companies may do is defend a salon owner or a manicurist under what's called a reservation of rights. The allegations are there. It hasn't been determined or hasn't been adjudicated that it was intentional conduct. And therefore, the insurance company will defend you under a reservation of rights. But if you are found to have engaged in intentional conduct, then the insurance companies take a position, well, we're not going to pay any judgment or any settlement because insurance policies don't cover intentional acts. So I'm kind of getting a little deeper into this, but I want to give our viewers a little background understanding of when there's liabilities, don't think that, hey, I have an insurance policy. Everything's okay. Yes, it helps, but you need to understand what is and isn't covered under most insurance policies that apply to nail salons.
Likewise, going back to our example of having professional liability insurance, it's my understanding that if you're working outside your scope of practice, if you're performing surgery, for example, your insurance policy is not going to cover you for that because you shouldn't have been doing that in the first place.
You're absolutely right. When you tender a lawsuit over to the insurance company, they're going to first look at, is it a covered act? So in this case, and what you're sharing here, was the service within an area that you were licensed to provide. So you may have professional liability insurance, but now you're engaging into the practice of medicine. You're cutting, clients are bleeding and something's happening. Then there's a question that the insurance companies have, wait a minute, I don't think your license allows you to start cutting people. So you're absolutely right. There's things that all insureds, or in this case, manicures, should stay away from because you do potentially risk taking yourself out of insurance coverage.
We can make this even broader because this applies to those who have insurance to perform hair services and skincare services. And that's why we do have within our industry insurance companies that are targeted and know our industry very well. That's always my recommendation is that you seek out not just any insurance company, but one that specializes in what it is that we do as licensed beauty professionals.
Right. Absolutely agree. So we talked about the professional liability. I briefly touched upon the employment stuff. And then there's next type of insurance in terms of liabilities, also related to employees, workers' comp. So say you're that owner and you have an employee who got injured on the job. Maybe it's repetitive motion performing their services. Maybe they got injured in some other fashion, but it is an actual work-related injury. Well, here in the state of California, all employers are required to carry workers' comp insurance. That way, if there's an incident that the employee has the ability to go seek medical help, and also if they have to go out on some type of leave that they could be possibly paid for their time off, payment of their medical expenses, all that is required. And if there is an incident that occurs and OSHA is called onto the scene, the investigator has the ability to shut down a business or a beauty salon for not having workers' comp coverage. And you will not be allowed to open up again until you can provide evidence that you do have workers' comp coverage.
That's very different from the due process that would be required if, for example, the state board thought you were not clean enough.
Right. Definitely different issues. From the state board, one of their objectives is to ensure customers are safe. So, from a health and sanitation aspect, that's some of the things they're looking for. With respect to the workers' comp and OSHA, they're looking at employee safety, where there are dangerous conditions that could have contributed or lead to harm to an employee. The overarching principle is, hey, we want to protect people. But the two agencies have different missions. One is more protecting the public, meaning the customer, and the other agency is tasked with protecting the employees who are working for the business.
There may be specific requirements based on where your business is located that you can't just assume based on your survey of your colleagues on social media. Like, what do I need to open up my business? And then you don't realize that your own jurisdiction has additional requirements.
That's one of the points that we've emphasized on multiple podcasts. We encourage all of our viewers, all beauty professionals, do your homework, do your research. Don't just rely upon what you see or hear on Facebook or YouTube, because oftentimes the person who is giving you that information isn't working within your jurisdiction. They're not just physically located in that city, so they don't know the rules and the regulations that are required. Let's say, for example, wages. Here in California, there is a state minimum wage, but there are certain cities that have higher minimum wage based upon that particular jurisdiction. And you wouldn't have known that but for your own independent research.
Agreed. There's so much to know, and it seems the more you dig, the more you find. That sounds kind of cliche, I get it, but it's true, and that's why compliance is such a complicated issue because so many different agencies have jurisdiction over our businesses, whether we're working alone and certainly when we're working with others, it just becomes exponentially more complicated. Let's talk about the types of services we offer and the products and equipment we use because again, my understanding is that we're responsible for using safe products and using equipment according to manufacturer's instructions.
Within every industry, beauty industry included, you have to use products, tools, whatever it is that you need to provide your service. You have to ensure that those tools and products are safe, not only for you, the worker, but also for the customer in this case. I know that different manufacturers market products differently. Different manufacturers identify what ingredients are in their products. I'm not partial to any particular manufacturer. That's not my role as an attorney, but I would encourage all of our viewers to make sure you're doing your own homework. What ingredients are in this product? Where is it coming from? Does it look funny? Does it operate the way it should? If there's something off about it, to contact the manufacturer or the distributor to ensure that there's nothing wrong with the product. Now, assuming our viewers have done their homework, they've looked into it, and it was their understanding it was a safe product to use, and then there is an incident that occurs. Something's wrong with the product and causes an issue with a customer. Customer sues. Is there insurance coverage in that case? There could be two types of insurance that may come to play there. One is potentially professional liability policy, but there may not be an issue of did the manicurist do anything wrong or outside their scope of services. It's a product related issue. So another insurance that may come into play is what's called the CGL, general liability policy. That's what many of us know as the business insurance. And that can cover harm to somebody else on our property. It can cover harm to any personal property. So if you find yourself in a situation where it was a product related harm and you get sued, then I would recommend to our viewers that you notify and tender the lawsuit to your professional liability carrier as well as your general liability carrier. And I always tell my clients, make it the burden of the insurance carrier to say, no, you are not covered, and explain why you are not covered in writing, because there are times when we as attorneys look at it, we say, wait, no, I disagree. There is coverage. This is an injury that is within the scope of the insurance policy. Based upon the allegations of the lawsuit, there is coverage, and the insurance company is required to defend you and what we call indemnify, which is pay out any damages. If it turns out that the insurance company and the adjuster made a bad call, the recourse for our salon owners and our manicurists is to sue their insurance company for bad faith. I never want a situation where my client says, I don't think this applies. That's not this type of injury. Well, if it turns out that there was coverage and you didn't tender it, One, the client's paid out of pocket for all their attorney's fees and any settlement. Number two is you have no recourse against the insurance company because simply you never notified them of a lawsuit. They never said no. You never even told us there was a lawsuit. So I say make it incumbent upon the insurance company and the adjusters to explicitly state why they are denying coverage.
That makes me think of 2 things. The first thing is that you need to be upfront with your insurance company when you secure your coverage and let them know exactly what kinds of services you offer so that they can then tell you whether or not anything that you're doing is not within the scope of your contract. And then if you're looking to add any services or use any kind of equipment, have this discussion with your insurance company. Do that before you make the investment.
Absolutely. Research your insurance company, be open and honest and candid with them during the application process. Because if you withheld material information or you intentionally gave misleading, inaccurate information, you also run the risk that there's no coverage. As a carrier, the adjuster can look back to the insurance policy and they're going to look through all the information you filled out there. Maybe you say, I've never had a prior claim, or I've never done this, or I did do this, whatever the specific issue is. If there's any inaccuracy on the application that the carrier relied upon in issuing the policy, from the insurance company standpoint, that's their defense. You intentionally withheld. You intentionally gave us inaccurate information, whatever the case may be. So therefore, we have no duty to defend you. So you always want to be upfront with your carrier. And oftentimes the insurance companies have databases that they can cross-reference and check. And based upon information that is available in those databases, that'll have some type of influence over your premiums that you're being charged.
The other thought I had, Mike, was for those who are enterprising enough to think that they can create their own products. That's a whole nother category of liability insurance, is it not?
Right. So that's an area called products completed liability. I know that because I was in that field in the manufacturing space. So if you're creating, developing, manufacturing your own products, as the manufacturer, you're going to want the products completed liability coverage. That's much different than, say, the general liability coverage.
I know some people think, well, it's not a big deal. I'm just mixing something up in my sink. If you're using that product on clients, if you're packaging it, you're selling it, that is the kind of liability that manufacturers carry for themselves because they want to protect against the claims that their product hurt someone.
Right. No, absolutely. If you're selling or making products, using it, and especially if you're selling it, you want to carry the insurance coverage because you don't know what's going to happen when the manicurist that you're selling to is using your product and something goes wrong. You get sued as a manufacturer. That is a whole nother area. So for any of our viewers, if you're going to go down the road of start making your own products, we need to have a separate conversation on that one because a whole host of issues. And that goes to not just, hey, Mike, I created a new product. It goes to, well, do you have a company that you're using to create the products? Are you incorporated? Because if you're just selling a product as a sole proprietor, well, guess what? If there's a lawsuit, who's getting sued? You individually. So then we go into, okay, now do you have a business set up to sell this? Where are you making it? I mean, you can only make so much in your garage. I do encourage entrepreneurship, creativity, but if you're going to start making products that are used in the beauty industry that could potentially be flammable, and you're bringing in, like I was, 55-gallon drums of alcohol and acetone, you don't want that in your garage. I don't care how great your garage is. You don't want 3 or 4 55-gallon drums of acetone sitting in your garage because you're making some product that you're selling. That just doesn't work because now that's just being reckless and irresponsible because if something happens, you're taking out your family, your home, and potentially a couple of neighbors to your left and right. That's just irresponsible. And then you're going to get shut down by the fire department if anyone ever found out, the smells. There's just all kinds of problems that come with trying to manufacture, especially manufacturing flammable products out of your garage.
If you were using a contract manufacturer and say you didn't have any hands-on involvement at all, if you have your name on that product, you're liable.
Yes, as the brand owner, you're liable. Now, what's the recourse? If you're using a contract manufacturer, potentially you could sue the contract manufacturer, alleging that they failed to follow specific instructions in the preparation of that product. Unfortunately, being as litigious as we are here in America, and especially here in California, the first person to get sued doesn't necessarily end the lawsuit there. Now it's other parties, either upstream, normally it's upstream, other parties upstream are going to be brought into the lawsuit.
So, the simpler you keep your business, the less liability you have. If you were to work alone, you have to be concerned about yourself. You have to be concerned about your interactions with your clients, the products you're using. Mike, let me ask you this as well, because we obviously work in a world that's dominated by technology. Are there policies that also cover us for things like data breaches and violations of people's privacy in that respect?
Yes. So that would be typically covered under a general liability insurance. And what you would do is get what's called a rider. It's like an add on. In layman's term, it'd be an add on. So you're telling your insurance company, in addition to my property, the theft, injury coverage, I'm concerned about a breach of my credit card information, client credit card information, email breaches. You can request that through your broker and they'll get a rider. They'll give you a quote for what it's going to cost for that additional rider, and then that'll be added to your insurance policy. So that's a very great point, Jamie. Nowadays, with cybersecurity issues and breaches, I do encourage our viewers to ask your broker about cybersecurity coverage.
I'm also thinking about our liability when it comes to interacting on the internet. I know ADA compliance is an issue when it comes to our website. So even protecting ourselves from being sued for not being ADA compliant on the internet, which I mean, I know sounds strange to people, but ADA compliance isn't just in the physical world.
Right. This is an interesting area. I've been exposed to it more, say, the last 3 or 4 years. Some of you may know I also work as counsel for a pharmacy law firm. In that capacity, I've had pharmacy clients who were sued for ADA issues related to their website. Interestingly, these pharmacies, where we call closed door pharmacies, there is no walk in customer. And the only way you would have known about them is probably through your doctor who orders from this particular pharmacy. And in some cases, the plaintiff or the person who sued was not even in the same state as the pharmacy. So the client's thinking, well, how is this person going to come pick up drugs in my pharmacy when they're on the other side of the United States? The way the law is written, it doesn't discriminate against where the plaintiff is located. If that person has access to the website and is trying to navigate the website and is unable to do so because maybe the font's too small, it's not clear, whatever the reason is, that is a potential violation. And so I encourage those of us who have internet web presence, make sure your website is ADA compliant. There are different apps or software, I should say, that can be added on as a module. What happens is when you scroll your mouse over a certain word, it enlarge the font right there. You can read it. Other software programs will read audibly the web page so that someone who's vision impaired can know how to navigate it. I mean, it's not too expensive. I do encourage you to do that because I know that from my own personal experience, resolutions related to websites, they're anywhere between $20,000 and $50,000 to settle.
Wow.
Yes. And that's exactly what my clients are saying. Wow. Well, do you want to pay me or do you want to get rid of this thing right now? So, word to the wise, get your website ADA compliant, even if you're like, I don't sell anything on my website. That's not what the law says. It's not whether you sell something. That's not the standard. Avoid having to pay me or someone like me between $20,000 and $50,000 to settle that lawsuit.
As much as we'd love to support you, Mike, we don't want to support you in that way.
Right. No, that's why I love spending time where you and I can discuss these issues, where I can share, and our viewers are being proactive. If anything, it's just to be educated, right? It's just to be educated. Okay, I know what this is about. I remember Jamie and Mike talking about it. And then from there, whatever you want to do in response to a lawsuit or a conversation, you have at least a starting point of good, credible information. I've always stressed I want our viewers to have credible information and not just from someone who's speaking from the hips and not really sure what they're saying, but is doing it for other reasons.
Amen. Let's leave it there with our discussion about liability, Mike. And I just want to remind everyone that we will be at Premier Anaheim teaching a class together. Look at this. We are teaching a class called Booth Rent Isn't Legal. Nobody told me on Sunday, February 23rd at 10 a.m. We're only teaching the class once during the weekend. So again, it's Sunday morning, February 23rd, 10 a.m. The class is free with your show ticket. Premier was kind enough, Mike, to give us a discount code, especially for our viewership that costs only $35 and gives you access to both days of the show.
Wow. That is great.
So I am hoping that not only do we have a wonderful weekend, but that we see a lot of our viewers and together have this conversation about what's affecting us here in California in particular. And for those who may be asking, will this be recorded? Will this be live streamed? I can answer that right now. It will not be live streamed, but we may have the opportunity to record it and post it later.
Great. Can't wait and actually meet some of our viewers in person and answer some of their questions.
That's what I'm looking forward to.
I do as well. I'll be around that day. And I may come back the second day of the show just to walk around, see what's going on, and talk to some folks, see if there's anything new and interesting that would be a good topic of conversation for our podcast.
Excellent. We're always looking for new topics. For those of you who have not had the opportunity to see our previous episodes, those are all available on our YouTube channel and on our website. And again, if you like what you see, even if you don't like it, please, we want your feedback. Give it to us. We can take it.
All right. Well, thank you everyone for watching today's podcast, and we look forward to seeing you at the show. Have a good day, folks.